Hello and welcome everyone to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and I'm very, very happy to have you all. And before we start off with today's session, friends, the second webinar for today, I hope you enjoyed the previous one as well. Thank you for staying up. Thank you for joining me. And so the important disclaimer is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So use of information is at your so, yes, friends, I am your host, Nipasa Pradhan, and today we have a very special episode lined up for you. And we are currently live on YouTube, LinkedIn, Facebook, and Twitter. So make sure you like, share, and subscribe to our channel. Our handle is Immigration and Jobs Talk Show, and stay updated with all our content. So, looking forward for this whole hour ahead of us because we are going to have a fun session again, and it is a familiar face that we are going to have today as a guest. So, yes, it is an absolute honor and a pleasure to welcome back our esteemed guest, none other than Attorney Chand Parvathaneni from SPB Law Firm. And Attorney Chand is a renowned immigration attorney based out of Dallas, Texas, with a wealth of experience in helping clients navigate the complexities of U.S. immigration law. So, how are you doing, Chand? Thank you so much for joining us today.
Hello, Nipasa, and hello, everybody that's watching the show today. Thank you for inviting me. And yeah, things are good. I mean, the weather is good. It's not too hot yet in Dallas. It's going to get very
Mhm.
bad in the next couple of weeks in Dallas. July is horrible. But right now, I
Right.
think the weather is good and just things are
Good,
going
good to
on.
see that. I mean, last time we spoke, I think you had bad rain. I remember behind you. I can see that window.
Yes, yes.
So, and
Yeah.
how's it going with the H-1B lottery season coming to an end, the first lottery? Busy, I know. How is it
Sure.
going, Cham?
Yeah, yeah. Yeah. So I think pretty much for most of the employment based immigration lawyers, this month of June, especially the last 2 weeks of June, is extremely busy. And the reason for that is June 30th. This is the deadline to file the H-1B cases. So all the people that
Hmm.
got selected in the lottery in the month of March, they've started filing, but most of the action is in the last month, especially June. And the last 2 weeks are
Hmm.
hectic because everybody they wait until the last minute. Most of the people wait until the last minute, and at the last minute, because it's the deadline, people have to file. So it's a lot of cases getting filed, the cap cases, and June 30th will be an absolute deadline. And USCIS, they do not extend the deadline for any reason. And what that means is people have to be cognizant about the deadline, ensure they get all their cases out to USCIS before the deadline is over. And
Hmm.
hopefully everybody's getting their filings done. And again, in the month of July, we'll have a better idea if if all the people who got selected in the lottery did file, if there is a chance for a second H-1B lottery or not. So those are the kind of things that we will know more in the month of July. But this month, at least, people are getting their filings out. And if there is a second lottery, we will know about it in the month of July, probably the last week of July.
Absolutely looking forward for it, Chand. And, maybe when we meet next, we will be talking about the second lottery. Who knows? So let's hope that, you have I know it's very busy for you and for all you folks out there who are in this session with the H-1B lottery. And thank you so much, Chand, for joining us today. I am already looking forward for this session today. I know it's going to be a very, very good one. So, folks, wherever you have joined us from, I'll just like to tell you that Attorney Chand is here. So, if you have any questions directly, you can comment them wherever you're watching, whether on YouTube, LinkedIn, Facebook, or Twitter, and we will be very happy to take them up. And it's great to have you with us again, Chand. So, today, we will be talking about this very crucial topic, and that is how to start the green card process for H-1B, L-1, and F-1 visa holders. So I really hope that it's going to be a very insightful one. And you folks keep commenting, all right? So, Chand, what can folks expect from us today in this session?
Sure. So most of the people who come to US, especially people on non-immigrant visas, they're coming here for a reason. They want to improve their career, whether it's on F1, whether it's on H1, whether it's on L1. They're either trying to get a better education, higher education, or probably get more experience in their occupation, and so on. And down the line, most of the people, they're looking for options. And if they like the country, they like their job, they like their career, the next most the common thing that normally happens is people look for ways to apply for a green card. And the green card process, it's a very lengthy process, it's a complex process, but there is a process. And US, in the entire world, it is one of the most welcoming countries in the world. And that is the reason why most of the people who are not born in US, they come and settle down in US, because there are a lot of options, whether it is family based, whether it is employment based, whether it's asylum for those people who are qualified, and whether it's self sponsorship. If somebody is extraordinary, somebody is very talented, they don't even need employment sponsorship. So there are various ways where people come and get a green card in US. Because the eventual goal for most of the people who are looking at US is to settle down in US. And people on non-immigrant visa, they cannot stay forever in US. So if somebody likes US and wants to stay back in US permanently, they have to go through the green card process. And today's show, what we're going to talk about is various kinds of the green card options that are available. People think it is only through employment based or only through family based. And there are options, and what we will use today's platform is to talk about various options, all the kind of ways in which somebody can pursue the green card process.
Absolutely. And I'm sure everyone out there is also very excited, who are already maybe are under various kinds of visas and are looking forward for this green card process to go further with, So yeah, let's move ahead then with our questions that I have for you, Chand. And this first one is a very, very
Sure.
important one. And that is, what are the essential steps involved in moving from an F-1 visa to a green card? And if you can also provide a step-by-step guide, for this transition.
Sure. So transitioning from an F1 visa, which is basically the student visa. So most of the people who are abroad, they want to come and study in US. US has very good schools, very good universities. So they come on an F1 visa. And transitioning from an F1 visa to a green card, which is the permanent residency, it's a complex process. It involves a lot of steps, and everybody's case is different. And we'll talk about various common pathways that people use to get a green card after entering US on an F1 visa. So the main thing is F1 is a single intent visa. So F1 is not really a visa where you really want to use it for getting a green card. However, what happens is people come to study in US, and over a period of time, they make friends and they start loving US. They probably get a job, and while they're working in the job, they like their career. So they look for pathways, the pathway to get a green card. And in students, normally most of the students, what I typically see is this is what people typically do when they're a student. They go to school, they complete their education, and they get something called optional practical training, which is basically a means to work in the United States. Since most of the students, they get very high quality of education here in US, they're able to find jobs. And OPT is how people typically find a job initially. And once they find an OPT employer, most of the students, they have employment. And what that means is majority of the students that I see, they typically go through this process called employment based green card process. So all that basically means is you find an employer, the employer sponsors your green card. That is the most common way that people typically get a green card when they are a student. And the way it works is they graduate, they are eligible for optional practical training. Because they're eligible for optional practical training, they get a job. And in general, people can work for 24 months on OPT. And if somebody is from a STEM field, science, technology, engineering, and mathematics, they can work for an additional 24 months. And during this period of time, they're good to stay in the country, they're good to work while on F1 visa. During this period of time, what happens is their employer normally will file a H-1B petition for most of the folks, especially the STEM folks. And once the H-1B gets filed, they can stay in US for up to 6 years. And the 6 years is basically a stepping stone to a green card, because people have only 6 years. And most of the people, what they do is in those 6 years, they find a way to get their green card sponsored. However, the big challenge is getting through the H-1B lottery. So assuming they go through the H-1B lottery, they get through the H-1B lottery, they work for the employer is happy with them. What typically happens during the H-1B period is the employer will decide to sponsor them. And the employer sponsorship, it's again a complex process. So they have to go through a process called labor certification. So when the employer decides that they're going to sponsor the student who has become their employee, so the first thing they'll have to do is do something called the PERM recruiting process. So they go through the PERM recruiting process and finish that process, and then they go to Department of Labor and they apply for this thing called the PERM application. And that is step number one. And once the PERM is applied, the PERM gets approved, there is another step. So the employer has to again come back and go back to USCIS and apply for something called an I-140. So the I-140 again takes some time. This entire process is probably about a 1.5 to 2 year process. So this entire PERM and I-140. So during these 2 years, this I-140 is done, the PERM is done, and at that point of time, the employee becomes eligible to apply for the 485, but there is a caveat. The priority date should get current. And normally what happens is for most of the folks who are not born in India or China, the dates typically become current or they're relatively close to becoming current. But for people in India, the priority dates are very, very backlogged. And the reason for that is there is something called a 7% quota. And because of the 7% quota, what happens is there is a lot of oversubscription from countries like India and China. India and China has a lot of people who are applying for green cards under employment-based categories. So for anybody that's born in China or India, they have a lot of backlog. And what that means is even if they have this entire process done by their employer, they probably have to wait for a couple of years before they're actually able to apply for a green card. But in summary, these are the steps that a student will have to pursue to get a green card while going through the employment-based category. So that is the first option that typically is used by most of the students. And then there is also this option about family-based sponsorship. So family sponsorship is where you have an immediate relative who is a U.S. citizen. And when you say immediate relative, we are talking about a wife or a parent in some cases. So if you marry somebody and your spouse is a U.S. citizen, then what happens is you can directly file for the green card. There is no waiting period. Unlike employment-based green cards, where there is a priority date, you have to wait. If you are an immediate relative of a U.S. citizen, so you marry a U.S. citizen, you are eligible to immediately file for a green card. So some people, they find somebody here in U.S. and they like them, and they will get eligible to file under the family-based sponsorship. And sometimes they have a family member, for example, a brother or a sister. So they might also be eligible to file under the family preference category. So the family sponsorship is also one way, but again, the numbers are not as high as employment-based category. Majority of the students typically go through employment-based green cards, but some of those students who become eligible because they have an eligible family member, they can use the family sponsorship. So apart from these two, there are also other pathways, and we'll talk about two things. One is asylum, and the other one is self-sponsorship. So asylum is where if somebody fears for persecution in the home country, they can go back to USCIS and ask for asylum. And asylum is a tough application, and they require a lot of evidence. So asylum is not something where anybody can just go and apply for asylum, but it's an option out there if somebody really has a fear of persecution in their home country and they really have reasons to back it up. So asylum is an option that I do see some people use. That being said, they should be persecuted in their home country. So there is a lot of burden of proof. And again, it is not something that is widely used, but it's an option. And there is also another option that a lot of people use, but India cannot use it. There is something called diversity visa lottery. It's called the green card lottery. India does not qualify, but some countries who have underrepresentation, they can use diversity visa. So all that means is they enter into the green card lottery. Every year there's a set number of green cards issued based on a lottery. So those people, what they can do is they can go through the green card lottery and apply. And one thing to understand is it is not available for India. It is there for a lot of countries which have underrepresentation. A couple of countries in Africa, they have a very low representation, so they can use the diversity visa. But again, that's an option out there, not used by a lot of people in India. And there is something called self-sponsorship. So there are two categories under which somebody can self-sponsor. So basically, if you are a student or if you're an employee and you have extraordinary ability, if you have extraordinary ability, you can just file for the green card yourself. So there is this category called EB1A, and then there is also this category called EB2 NIW, National Interest Waiver. So there are two categories where, whether you're a student, whether you're on H-1B, whether you're on L-1, if you have that extraordinary ability or exception ability, you might be able to self-sponsor your green card by applying yourself. So you just file the I-140 petition yourself. You go to USCIS. You don't need an employer. You can apply for a green card. And I do see a lot of people from India and even China recently use EB1A or EB2 NIW, National Interest Waiver, and a lot of people are being successful. However, it is not for everybody. You do have to prove extraordinary ability, and USCIS, they have a list of a set of the qualifications, and they only want at least three of those things to be proven. So things like, do you have an internationally recognized prize or an award? Did you receive it? Do you have a membership in an association that is outstanding for their members? Did you publish any material in any major journal in your field? So there are a whole couple of things. Do you have a very high salary, or did you lead any distinguished organization? So there are a couple of factors, and if you satisfy at least three factors, you might be eligible to apply for EB1A. So EB1A is being used by a lot of Indians, and if you are having some extraordinary ability and you want to showcase it back to USCIS, you might get an approval under EB1A. So for anybody that has won a lot of awards, or has won international prizes, or you have a lot of journal articles, you are a distinguished person in your company, you have something to prove to USCIS that you have extraordinary ability, people should be pursuing EB1A. It's a very good category. US wants to encourage people who have extraordinary ability to immigrate to US. So this is a category that is getting very popular among Indians, and this is something what everybody should at least explore, especially if you have a lot of awards, a lot of prizes, a lot of contributions to your industry, and so on. The burden of proof, however, is very high. So there is this another category called EB2 National Interest Waiver. National Interest Waiver, again, it does not require an employer. You can just self-sponsor yourself. And it's also a very good way. So you can apply for an I-140 without depending on an employer. And this is an immigrant visa, a green card filing, where you do have to prove that you have exceptional ability, or you also have to prove that, approving that particular I-140 is in the national interest. So if your work, you're doing something, or you're contributing to to the nation, and you're able to show that it is in the interest of the nation to approve your case, you might be able to apply EB2 NIW, National Interest Waiver. And again, this is also getting very popular with Indians lately. A lot of Indians are applying, and the beauty of this NIW is it is not as stringent as EB1A. EB1A is a little bit more stringent, requires a lot more evidence. EB2 NIW, the burden of proof is a little lower, and I do see a lot of people being successful. So the way to file this EB2 NIW to get your green card is get a lot of what do you call expert letters. So basically, the people that you worked with, people who can vouch for you, people who can give you a recommendation. So get a lot of recommendation letters explaining your contribution to the field, to the occupation. Demonstrate your achievements by properly documenting your achievements. Show what kind of an impact it has on the society. For example, you have built some software, and and your software, it has helped a healthcare company. Or for example, you're working in a healthcare company, and the software development that you're doing for that company is directly contributing to help the nation. You might be able to document and use it. You can show your educational background. You have a master's degree. You can show it. you can show your publications, you can show your awards. So these are all these things that you can show to show that it is in the interest of the nation to grant you a waiver. So NIW is a very famous way. It's getting very popular nowadays. So people should explore EB2 NIW if you don't have an employer. So these are the kind of typical ways that people use to get the permanent residency and get the green card.
Thank you so much, Chand. And well, talking about it, maybe folks out there could maybe get to know what is a green card and what is permanent residency. I mean, how long does a green card last, at least?
So green card for most of the employment-based cases, it's given for 10 years typically. But if somebody is marrying a U.S. citizen, they normally get it for 2 years. It's called a conditional green card, and then they eventually have to file for removal of conditions and then get a 10-year green card. But most of the green cards typically are for 10 years. And normally what I see is people after 5 years, they typically want to apply for citizenship. They qualify for citizenship after 5 years. So most of the folks, before the green card is going to expire, they already have their citizenship.
Okay. Okay. Thank you, Chand. And, I'll just quickly say hi to friends out there who have commented. So hi to Shaukat, Akbar, Ricky, Nandini, Atota, Prakash, Zarek, Amy, Dipti. Thank you so much for your questions. We will take them up. You just have to stay with us. All right. So, quickly though, I mean, earlier we spoke about the OPT. So I wanted to just ask you about this one. During the OPT period, what options are available for students who have completed non-STEM courses? Quickly, briefly, Chan.
Sure. So when people do STEM courses, what happens is they get extra time on OPT. But assuming somebody is on non-STEM course, so they do get a 12-month OPT. So 12 months is what they can stay back in the country and work for a company. And the beauty of OPT is the salary requirements are not very high. So they can just even look for a very, very entry-level job. They can start off and start their career. So so the main things are for the first 12 months, they can stay back in the country and they can pursue their employment. But once that 12 months is done, they have to look for options. And the most common options are the H-1. H-1 is challenging. The reason it is challenging is because of the lottery. So they have to go through the lottery. If we get selected in the lottery, more than likely their employer is a valid employer, has a bona fide job, they can get an approval. However, we do see every year, we do see cases where the OPT is over. If it was STEM, they can additionally get 2 more years, so they have some more buffer. So they have 1 year buffer plus 2 more years of buffer. But when you say non-STEM, they only have 12 months. So they don't really have that extra 2 years of cushion that the STEM OPT people have. And what that means is they need another option. And if they don't get the H-1B, the only other options they can think of are they can think of O visa, but again the burden of proof for a O visa is very high. So if they get a O visa, they can use an O visa. If not, they can probably look for a J1 visa. But again, J1 visa, not everybody qualified. There is also this thing called exempt H1B visa. So exempt H1B visa is for those folks where they don't have to go through the lottery. For example, if somebody finds a job at a qualified employer, so for example, the research organizations, uh, some research organizations, they typically are considered as exempt. What exempt means is even without going through the lottery, these entities can hire somebody on H1. So for example, if somebody gets a job at University of Texas at Austin, for example, even without going through the lottery, the university can file for a H1. So a lot of these folks who don't get picked up in the lottery and their OPT, because it's only 12 months, it's expiring. So uh, uh, so one of the things they should do is look for those kind of employers and see if they can find a job, because those employers don't have to go through the lottery. They are exempt employers. So finding employment with an exempt employer is one of the options. If all of these don't work, to stay back in the country, they might have to go back to school. They might have to ensure their F-1 visa is still active, and what that means is they have to again enroll in a course. They have to ensure they're following all the F-1 regulations strictly, and so on. And some people, while they're on F-1, they want to work And for those folks, CPT might be an option, but CPT, there are very, very strict rules over CPT. So they have to make sure that if they desire to work under CPT, they check with their school DSO and ensure that they are following all the F1 regulations and so on. And the other option is, even during OPT, some people might be able to find employers who are willing to sponsor their green card. And I've seen a couple of folks where they were not successful in the lottery, but they found an employer who was willing to sponsor their green card. They sponsored their green card and went through the process. So overall, uh, if their OPT is ending, people do have to ensure that they take some proactive measures to ensure that they still have a valid stay in US. And what that means is either continuing their F1 or changing to another legal valid status.
All right, great. Thank you so much, Chand. Well, we have stepped in quite a bit into the topic, I would say, and thank you, Chand, for those detailed explanations. So, folks, if you have questions directly to Chand, maybe you really have a complicated case and you really need a one-on-one with Attorney Chand, why not contact him directly? Call him in the number 817-523-8247. You can even email him, that is law@spblawfirm.com, or even visit his website, spblawfirm.com. And we'll quickly go for a short break. We will definitely talk more after the break. But friends, don't go anywhere. Stay with us on Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Are you looking for a flexible work from home opportunity? We've got just the thing for you. Work just 2 hours a day and earn a monthly pay of 5,000 Indian rupees plus 500 Indian rupees for every meeting you attend. Earn up to 20,000 Indian rupees per month. Your responsibilities will include managing social media posts, creating engaging content, responding to messages, monitoring analytics, conducting research and data entry. All you need is your own computer, a reliable internet connection, knowledge of LinkedIn, basic English writing skills, ability to work independently, Aadhaar card, ability to use your real name on social media. Ready to join us? Email swapnil@staffinglyhealthcare.com to apply. Don't wait. Join us today and start your journey towards a flexible and rewarding work from home career. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and thank you so much, Attorney Chand, today for joining us and, for sharing such valuable insights just before the break. So we are discussing today about this topic, friends, and, how to start the green card process for H-1B, L-1, and F-1 visa holders. I hope that you are enjoying this session so far. And if you have more questions, keep commenting. We'll be taking them for sure. So, yes, Chand, thank you so much for being so detailed and explaining. So, my next question to you is it possible, to apply for a self-petition visa while studying? And what are the requirements for doing so?
Um, sure. So when we talk about self-petition, so normally in the U.S. immigration world, it's either the employment-based sponsorship, which means that you need an employer, or family-based sponsorship, where a qualifying relative should sponsor your green card. So majority of the immigration system is built around, for the green cards, it's built around a sponsor sponsoring the green card, whether a family-based sponsor or an employment-based employer sponsor. However, in the immigration world, they do understand that some people might not have a sponsor, might not have an employer, might not have a qualifying relative, but there is a very good reason why they should be given a green card in US. And from that perspective, there are two options that we briefly discussed a couple of minutes back, and that is EB1 option. So EB1 is a very, very good category. It is like the highest category where people get the green card in a quickest manner. So there is one category where if they are highly qualified, somebody might not make a lot of money, for example, but they have done a lot of research, and they wrote a lot of papers, and they are contributing to the research in some field. It could be any field. It does not always have to be technology or medicine or anything. It could be any field. But if they have risen to top of their field, sometimes even if they might not make a lot of money, but they are at top of their field, and there is a category which is EB1A. This EB1A category is basically somebody is extraordinary and extraordinary in their field. It could be arts, it could be science, it could be sports, it could be technology, it could be anything. And those are the kind of people who can self-sponsor. For example, somebody is a cricket player. We have seen in the recent the cricket matches that are happening in US, there are people who are on H-1B visa who are playing for US, for example. So those guys, obviously, because they've risen to top of their field, they're participating in international competition. They've risen to top of their profession, which is, for example, cricket in those cases. Even though these players are from India, they might not have a sponsor here in US. They can self-sponsor their green card, and that is EB1A. So EB1A is used by a lot of folks, a lot of software folks, a lot of technology folks, a lot of entrepreneurs, and so on. So EB1A is definitely a very good way of self-sponsoring, but the burden is very high. And if you go to the USCIS website, they have a whole bunch of factors, about 10 factors. And if 3 of those factors are met, they can be eligible for EB1A. So everybody out here, if you go to the USCIS website, type in I-140 application, and when you go into the I-140 link, you'll see the EB1A, the factors. And I think everybody should at least familiarize themselves with those factors, because sometimes a lot of people, they are highly qualified. They just don't even think that as an option. Somebody's working in a very, very high role in a good company who's making a very good salary. They might even qualify for EB1A. So, or you have some patents. You are an amateur person working for some company, but you have some good ideas, and you patented some of your ideas. You have a lot of patents, for example. You might be a good candidate for EB1A. So, so EB1A is typically the best way if you get eligible for self-sponsorship. And there is also EB2 NIW. EB2 NIW is also good. The problem, however, is for India, it comes under EB2 category. So the EB2 NIW, the National Interest Waiver, it is a form of self-sponsorship. So if one qualifies, you can go ahead and apply for NIW, National Interest Waiver. You can get an approval, EB2 I-140 approval. The problem is, if you're from India, the EB2 dates are in 2012. And what that means is, even though you get this NIW, you cannot really get a green card for a very, very long time. If you're from another country, for example, like Bangladesh or Pakistan, their priority dates, they move ahead very quickly. So for them, the EB2 NIW is very, very useful, because their dates are not backlogged. For India, the dates are backlogged, but still, it's a good option. So a lot of people do apply for NIW, because the good thing about having an NIW EB2 is, even though it takes time for you to get a green card, the fact that you have an I-140 approval, based on that fact, you're not dependent on an employer. So tomorrow, if you have to get extensions for your H-1B, or tomorrow if something happens, at least you have that approval, you have that I-140 approval, and when the date becomes current, you don't have to worry about an employer sponsoring you. So EB2 NIW is also a very good option. The burden of proof is definitely a lot less than EB1A. So these two are the most common self-sponsorship options out there. And the next one is, there is something called EB5. So EB5 is not truly something where you self-sponsor. But
Mm-hmm.
again, you're not really dependent on an employer. You have the money. So EB-5 is basically the investment visa, the investment green card. So if you invest $900,000 or more, depending on what kind of an investment it is, whether it
Mm-hmm.
is targeted area or not, if you invest, if you have the money, you invest into an enterprise, you are able to generate more than 10 jobs, you might be able to get a green card. So EB-5 option is
Okay.
also out there, and I don't
Mm-hmm.
see a whole lot of Indians use EB-5. And the reason for that is because we are seeing the EB-5 numbers, and the EB-5 numbers for India, they're not really in thousands in a year. So EB-5, it's low volume, but it is out there if
Okay.
somebody has that kind of money and they're willing
Mm-hmm.
to invest and create 10 jobs. So EB-5 is also a good option where you don't really rely on your employer. So theoretically, these three
Okay.
are the best ways to self-sponsor.
Okay. Thank you so much, Chan. Thank you so much. And so basically, we have the investor visa, the EB2, the NIW, and EB1 categories. So thank you for clearing that out for us, Chand. And I think we should take up one viewer question so that, I mean, they've been waiting for quite some time. Let's take up one, and then
Sure.
maybe if we need to, we will jump into our questions back again. So let's take this one. This is from Dipti on YouTube. Can my friend whose H-1B visa is currently under renewal request that his company file for his green card simultaneously, or must he wait until the renewal process is complete? Oh, there is a
So I
continuation.
think
His company is hesitant, but he needs an approval notice for his wife's benefits as soon as possible.
right. So I think it's a good question, and a lot of times what happens is a company gives somebody a job offer. They join them on H-1B, and
Mhm.
sometimes the companies will ask somebody to wait for 1 year, 2 years, or get an approval. The reality is USCIS does not require H-1B to be approved. So if a company wants to sponsor somebody, they have a job, they can start right on day one. They don't really have to wait for that H-1B approval, or there is no like a time period, like a time that you have to wait. There's no waiting period. So because I've seen some companies where some people come to me and say my company wants me to work with them for at least a year before they can sponsor a green card. It might be their internal requirement, but from a USCIS perspective, from an immigration perspective, there is no waiting time. So a company can file for a green card independently of the H1, whether you're on H1B or not on H1B. The company can still start the green card process if they have a job out there. So what that means
Okay.
is normally what I see in the industry is some people negotiate well with their employer, some people don't negotiate well with their employer. The people that negotiate well with their employer, they get their green card sponsored a little quicker. So
Mhm.
and those people who don't negotiate well with their employer, the employer typically might delay the process, because end of the day, this whole employment, it is give and take. The employer
Mhm.
is providing employment, but employee is also providing services. So in the capitalistic world, both are very important. The employer is important because he's providing a job, and entrepreneurs provide jobs, which is good for the economy. And the employees
Mhm.
are also able to negotiate. They're also working for the company, and they're a big part. So what people should do is there is no waiting time. And the way I see it as an immigration attorney is the sooner you get into the green card process started, it is good for you, because it's a very slow process. Right now, the perms are taking close to a year after you apply. But to even apply for the perm, it's like almost a 6 to 8 month process. You have to get a prevailing wage, you have to advertise, you have to follow all the rules of DOL very, very strictly for the recruiting. So the
Mhm.
entire green card process to get an I-140 approval is close to 2 years. So if the sooner you can get this whole process started, it is better for you, because you'll get the I-140 approved, and you don't have to worry about not having an I-140 when you're in the 6th year of your H1. And not only that, if you get an I-140 approval, your spouse becomes eligible for H4 EAD. So the spouse can start working, because that's a feature out there. So my
Mhm.
thing is, the sooner you can get the green card process started, you should ask your employer to start that process. There is no USCIS requirement that you have to wait for a certain time, and
Mhm.
the sooner you get it done, the sooner I would say the more safer it is, because you don't have any surprises, especially considering that perm is taking so long nowadays.
So true, Chan. Thank you so much for taking that up. And Deepthi, I hope that you got your answer. If you have more questions, we are here for some more time. So, yes, I think we have covered already about, the general pathways to a green card. Thank you so much, Chan, for clearing that out. And also, we covered a little bit about the process and timeline. So, let's move on. Let's take up another question from the audience out there. Let's take this one from Prakash. I work at an end client for a consulting or staffing firm. PERM is submitted to DOL and is under process. Expected to take at least 5 to 6 months to move to the next step, that is I-140. Yeah, that's it. Okay, now the end client wants to hire and sponsor me full time. Should I take the offer considering it will set my PERM process by at least a year? Because end client might need to redo the filing. What do you suggest?
Sure. And I think I see this all the time because, and unfortunately, the reason for this kind of a problem, which is very common, is because the perm is a very, very lengthy process. I mean, right now, perm, right from the day the company starts the process, they have to start off with something called prevailing wage determination. It's a 6 months process. Then you have to advertise, a 30-day process. Then you have to wait for the cooling off period, which is 30 days. And then you apply for the perm. And once you apply for the perm, from the day of application, it is taking close to a year, almost 12 months for DOL to take a decision on perm. And what this means is, just to get through the first step of the perm, you are looking at close to a year and a half, or little over a year and a half. And
Mhm,
it is very natural that people get other offers. So year and a half, people might have another offer. And I think that's what happened uh, to this person. What happened is they found another better offer.
mhm,
Now the problem is everything will be reset because the day you file the perm, that is the priority date, but that priority date is locked only if the I-140 is approved. So if the first employer he does not file the I-140, the priority date is lost. And what that means is, if you take up this new offer, you take up this full-time offer, and you have this employer start the process all over again, I don't even know when they can file the perm because they cannot file the perm right away. There is a lot of steps that the company has to do
true.
before they can file the perm. So my guess is at least another 6 7 months before they can even file the perm. So you're losing the priority date. That being said,
Mhm,
you can stay and work in the country for 6 years without having an I-140. So if you are very, very early in your H-1B, you still have a lot of time. I would say maybe if your offer is good, jump to this new company and let them sponsor. But if you're on the last stages of your H1, you're getting close to the 6 years, you will not get an
mhm,
extension unless your perm process is done, or at least it's more than a year since your perm has been applied. So depending on where exactly you are in that 6-1B H1B period, you might have to take a decision. But one thing I can tell for sure is that your perm will have to start all over again. And so you have to basically, the new company, the new employer will have to start all over from scratch. So it is going to reset your timelines. And if you have a spouse, what that means is your spouse also cannot work because she will not
mhm,
get the H4 EAD. So maybe you have to basically think around all these lines and take
right.
a decision. But again, I see the problem. The problem is, again, the perm having to restart, having to reset all your timelines.
Mhm.
I mean, that's a bad thing, but again, that's how the current rules are.
Right, right. And I'll just say hats off to folks out there who have the patience. And I mean, there's no other way. You have to do it. So go on with it. All the best. Though it's lengthy, it is doable. And you just need the correct guidance and direction. So always consult an expert. And that is find an attorney. All right. So moving on, let's take up this next question that I got for you, Chand. And that is, for students. Uh, um, so currently pursuing their master's degree, when is the best time to start application for an F-1 visa to green card transition? And could they wait until they graduate or not?
Um, there's a lot of misconception on this topic. So a lot of people think
Mhm,
that if somebody is on F1, they have to wait until they get a H1 to actually ask their employer to sponsor for a green card. And a lot of times, even the employers think the same thing. They think that somebody has to be on a H1B visa before they can sponsor somebody's green card. The reality is you don't have to be on the H-1B visa. So to me, what that means is the sooner, if you have somebody willing to sponsor your green card, the sooner you find a sponsor, it is always a good idea for them to sponsor, because the way I see it is US has very, very good opportunities. And I always support people who want to become US green card holders, because there is a lot of things, lot of opportunities that are available in US. And not only that, if somebody is being given a green card under employment based category, USCIS knows that these people are qualified, either EB2 category, they are having an advanced degree, EB3 category, they are skilled workers, or they have a bachelor's degree. So, so what that means is, if somebody has those skills, they are qualified. I think if they should start looking for a sponsor right from the day they're eligible. That being said, in reality, what happens? In reality, when somebody is a student, when they're on their F-1 visa initial stage, they typically don't find sponsors because they're still studying. And until they complete their course, they don't find employers. And normally what happens is people finish their degrees, for example, a master's degree, they come out into the industry. And that is when they really meet the employers. So when they're on their F-1 visa, but under OPT status, if they have an employer, and that employer can actually start their green card processing. They can actually start doing the PERM and so on. Okay, there are certain things, because F1 is a single intent visa, so they might have to look at certain things closely. But there is nothing wrong in green card process starting for somebody on F1 visa. And because everybody's case is different, they might have to kind of look at it. But somebody on F1 visa, somebody who is working in OPT, their employer can start the green card process. And to me, the minute they find employment, they're working in OPT. If their employer is satisfied, if the employer thinks that they're doing a good job and they're working, they're doing their tasks well, and they're valuable asset to the company, that is when I think the people, even if they're in F1 visa in OPT status, they should at least bring this to their employer and ask them if the employer can sponsor their green card, if the work they're doing good is valuable, and the company intends to keep them on a long-term basis. So what that means is you don't really have to wait until your 3 years of OPT plus STEM OPT is complete, and then you get picked up in the lottery, go through the H-1B process. No, you don't have to wait till you get a H-1B. You can do it the minute you find an employer. You can, if the employer is convinced that you're a valuable asset to the company and they require you full-time, permanently working for their company, that is the time I think the green card process should start. So the sooner you find employment is basically what I say is when the green card should be started, and not wait until you get a H-1B. Okay, so the sooner somebody graduates, gets employment, and the employer is a good employer, and you see long-term career with that company, and you want to stay back with that company for a long time, I think that is the ideal time to start your green card process. And don't really wait until you get your H-1B, because the rules don't require you to wait until you get your H-1B to start your green card process.
Definitely, Chand. Thank you so much for taking that up. And we discussed about, some specific scenarios and eligibility. So keep those things in mind, friends. You really do not need to wait for your H-1B to start your green card process. And I'd say all the best for all you folks who are, planning on getting your green card soon. And yeah, update us maybe about your experience as well. So yes, Chand, I think we should move on to some questions from the audience now. Yeah, let's take up Rakhi. This is on YouTube. What is the difference between adjustment of status, AOS, and consular processing, CP? And which option is recommended for F1 visa holders seeking a green card?
Sure. So, we will talk about adjustment of status versus consular processing. So if somebody becomes eligible to file for a green card, so basically I'm assuming the dates are current, or somebody is eligible to file the green card, the actual green card. So at that point of time, pretty much people will have two options. One is adjustment of status, and that is basically if somebody is already in US. So for example, somebody is qualified for a green card, say their employment-based green card, their date is current. Or for example, somebody married a US citizen and they're in US and they're eligible to file for a green card right away. So typically you'll have two options. One, you can file a green card by staying in US, and requesting USCIS to grant you a green card. So that is called adjustment of status. So you are in United States, you are in some non-immigrant status, and you are asking USCIS to convert and adjust your status from a non-immigrant visa to a green card holder status. So that is what is adjustment of status. So you want to stay back in US and you want to get a green card without traveling out of US. So that is pretty much what is adjustment of status. The other option is consular process. So in that consular process, what you are saying is you're basically saying, I'm eligible to get a green card right away, but I will go back to my home country and I will get my green card in the home country. So what you do is you apply with USCIS your immigrant petition. So what that basically means is either your I-140 or your I-130 should be approved, and once that is approved, you're not really filing the 485 application, which is the adjustment of status application, but you are telling the government that you want to go back to your home country and get a green card at the home country. And some people do it for various reasons. Uh, so, for example, uh, for example, parents. So they are out of the country. Say they are in India, and their child is a U.S. citizen, and they want to sponsor their parents. So the parents have a choice. So the parents can get a green card in the home country. So the consular processing is an option that is available, and it is typically used by those folks who are already out of the country. But if somebody is already in US, for all practical purposes, it is more easier if they just do a AOS. But if somebody is out of the country, they use consular processing. And that being said, in your case, F1 visa holder, F1 visa holder seeking a green card. So the big thing about F1 visa versus H-1B is F1 is a single intent visa. H-1B is a dual intent visa. And when you have a single intent visa, you cannot really have a dual intent. And what that means is, if you want to become a green card holder, F1 visa is not the right visa. So on the day you got your F1 visa, you cannot have a dual intent. But what I normally see is when people initially get their F1 visa, they get F1 visa because their intent is to study. But down the line, normally, when I say down the line, when they finish their studies, when they find employment, that is when people really see what the labor market, the job market is in US. That is when typically people want to get a green card, and that is when their employer files for a green card. So even though initially the intent was F1, down the line after they found employment, if they have an immigrant intent, the I-140 can be filed, the PERM can be done. And again, if people on F1 visa, they need to travel back and forth a lot for some reason. I normally recommend consular processing because they're going back and forth, and every time they come into the country, they do really have to show the intent. They have to show they have to meet the standards of their visa. So if they're having to travel back and forth and they have a lot of time that they want to stay back on F1, I always definitely recommend consular processing because F1 is a single intent visa. But again, if your F1 is almost over and you almost got your OPT and you're about to transition to another non-immigrant visa, even adjustment of status can be done. We have done that in the past. We have done adjustment of status for F1 folks who have a priority date current and who have an I-140 current approved. So we have done AOS also. So every case is different, but definitely for some F1 visa folks, council process probably makes sense, which is why every case is a little bit different. You might have to talk to your attorney who's filing the I-140 for your specific case. And there are cases where for F1 visa cases, you might have to do it as a consular processing case.
Okay. Thank you so much. And Raki, I hope you got your answer. Thank you for your question. And Deepthi, whose question we took earlier, says, thanks a lot, Chand. So thank you, Chand, from Deepthi.
Thank you.
And then moving on, let's take up this
Thank
next
you.
question we have. Yeah, this is from Rashmi, asking, I am currently in the US on L-1B visa, which is valid for another year. What are the necessary steps and documents required to initiate the green card process through the EB2 category? And how soon can I expect to receive a green card if my employer sponsors my application?
Sure. So when you talk about EB2 category, so whether somebody is on L1 or whether somebody is on H-1 or even F-1, the employer has to follow the same standard, which is basically the EB2 process through the labor certification. So what that means is the employer will have to start the process. The employer will have to apply for a prevailing wage with the Department of Labor. They have to get the prevailing wage. They have to advertise your position. And if they successfully complete the recruitment part for your labor, they're not able to find any local people for the job, they typically will go to DOL and apply for the PERM. So they have to follow the same process. Whatever they do for the H-1Bs, they have to follow the same process, even though you're on L-1B. So what that means is you have L-1B valid for another 1 year. So your employer will have to do this entire PERM processing, get an approval, and then go to the next step, which is the I-140 step, and so on. And in terms of the documents, typically you'll require your educational documents from your perspective, your experience letters. Those are what are very important for the I-140 approval. And since you already got an L-1B approval, my guess is the employer already has access to all those documents. So the key thing is finishing the PERM recruitment, the prevailing wage, the advertising. That is the challenge. The reason I say it's a challenge is because it is very, very time consuming, and they have to follow very strict regulatory steps. But my guess is if the employer is willing to go ahead with the process, they can get through all of that steps, because there is a process and you follow the steps. And if they're able to do it, they'll apply for the PERM and the I-140. And to your final question on how quickly you can get this green card,
Green card.
a lot depends on the home country. Yeah, because every country's case is different. You get what is called a priority date, and then you have to look at the visa bulletin, and the visa bulletin will tell you for the country of birth. So your country of birth, what is the priority date? So based on that, you can understand how long your green card might take. And if the date is current, you can apply for the 485 and you can stay back in the country. If the date is not current, what the company will typically have to do is they will have to use your I-140 approval and apply for an extension for your case and move ahead. But the good thing is you have about a year. So if your company starts the process right now, or in case they already started the process, so depending on where you are, you will have to look and see what's going to happen. But your employer can apply for EB2 process the same way as they would do for any other H-1B case.
Okay. Thank you so much for taking that up for Rashmi, Chand. Thank you, Rashmi, for your question also. And let's move on now to the next question then. This is from Manali. I am an F-1 visa holder with a bachelor's degree in STEM. I have secured a job offer from US employer in my field. What are the necessary steps to indicate the green card process through the H-1B and EB3 categories? And how can I ensure a smooth transition from F-1 to H-1B and eventually to a green card, considering the cap gap and premium processing options? Okay.
Sure. So you have a bachelor's degree, so you definitely come under the EB3 category. So EB3, the bachelor's category. So definitely you're qualified, but the employer, to start the green card process, they have a whole bunch of steps that they have to follow. So again, there are two things. You're talking about H-1B, you're talking about the green card. The good thing is both can happen, both can be pursued independently. So your company, they can decide to wait until you get your H-1B and then do the green card, or they can start the green card process right now while your H-1B process is also being pursued. So both can be done parallelly. You don't really have to wait until your H-1B is approved. So they can do it concurrently. And for the H-1B part, so for the H-1B part, if your H-1B is filed before your STEM OPT your OPT card expires, you get cap gap. So the cap gap is basically saying your H-1B has been filed before your OPT card expired, and by doing so, you automatically get an extension of your EAD card until September 30th. That is what is cap gap. So if your company is filing for the H-1B, it is good. You get the cap gap if your EAD card expires. And once your H-1B is approved, you can start working on H-1B. So that is one part. And for the green card, so your company should, again, depending on your role in the company and your company's requirement, the company, if they have a requirement, they can move ahead and start the green card process right now. And in my opinion, it's a good idea to start this process as soon as possible. So you can always talk to your company and get them started. That being said, some companies as a policy, what they do is they might need some time. Internal policy, nothing to do with USCIS. USCIS rule, your company can start the process right now, or do it at a later time. Okay, but I would encourage you to pursue both concurrently. Pursue your H-1B, pursue your green card, both concurrently. And if the company does both concurrently, you will save time on the green card process.
So true, Chand. Thank you so much for taking that up. And by the way, may I ask how many green card processes are you dealing with maybe currently or this year?
I deal with about like 1,000 cases in a year. When I say green card, I'm talking about the PERMs and I-140s together. So I deal over 1,000 cases in a year. And again, the stats are typically public information. So one can go to the DOL website and they can see how many PERM cases an attorney has worked on. So most of the, pretty much all the PERM information is public information available at the DOL website.
Right. Thank you so much, Chand. I would say, there's so much to talk about, but there's not enough time. So I think we will have to cover up another episode on this topic very soon, hopefully when you'll have time. And if you can, maybe please join us again in the coming week or the next week after.
So thank you so much, Nipasa.
Thank you. I hope you had a great time, and here's wishing you a very, very happy Thursday ahead. Thank you for joining us, Chand. It's always a pleasure to have you here on Immigration and Jobs Talk Show.
Thank you, Nipasa, and thank you all.
Thank you, Chand. So to viewers out there as well, thank you
you
so much for joining us. Yes, thank you for participating as well, with your questions. And if you have more queries or need further assistance, don't hesitate to reach out to us or to Attorney Chand Parvathaneni also from SPB Law Firm. So friends, thank you. And before we leave, there's also a very, very exciting news that I want to share with all of you. And that is, there is this very excellent opportunity, which is a work from home opportunity. And all you need to do is work for 2 hours from home. And this is a great news for all you Indian folks out there who have some free time at least, and maybe are busy doing many things, but you also have some time to earn. So you just need to work just for 2 hours per day, right? 2 hours only, and you have the opportunity to earn 5,000 rupees per month. And not just that, if you attend meetings, you earn 500 Indian rupees per meeting, and you have also the opportunity to earn up to 20,000 Indian rupees, which is huge. I mean, if you have the time in 2 hours, why not make that time count as well? So just send your resumes to sravanti.chodavarappu@higheritpeople.com. It is displaying on the screen. SRAVANTHI.CHODAVARAPU at higheritpeople.com. And your responsibilities in this job would be to manage social media posts, create engaging content, respond to messages, monitor analytics, conduct research, and also do data entry. So don't wait, just go for it, apply for this. And thank you so much, all you folks, for joining us today. Also, if you're looking for project placement or EATs, H4, green card, anything, you can always visit our website. That is www.higheritpeople.com. You can also email me if you need further queries or want to ask anything about immigration or jobs. And my email address is nipa@higheritpeople.com. You can also call me on this number or WhatsApp me on this number. That is 408-335-6444. So thank you once again, all you dear friends. I'm hoping to see you again. And don't forget to subscribe to our channel, that is Immigration and Jobs Talk Show, so that you will be updated whenever we have these very, very insightful webinars and also different content all about immigration and jobs. So stay in touch with us. And we are there not only on YouTube, but also on LinkedIn, Facebook, and Twitter. So feel free to contact us. And until next time, friends, stay safe and stay informed. Thank you. Bye-bye.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www